Hello, I'm Matthew Kolodziej. I'm the partner of the business immigration practice at JLG Group. I'm here at our headquarters in the financial district in New York City. And today we're talking about a very interesting development. The Immigration Service of the United States has announced the reintroduction, the reactivation of an entrepreneur parole program for foreign entrepreneurs that would like to start a business in the United States. Now, as some of you may know, there isn't currently an actual entrepreneur visa available to come to the United States. There's an investor visa program, but it only applies to certain countries, and there's certain limitations to it. So for many foreign nationals, in particular Chinese foreign nationals and Indian foreign nationals, there really isn't a solution for entrepreneurs who would like to start their own company, even if they have a very successful new idea that they want to implement, even if they've raised funding, okay, because most visas in the United States require you to be employed by another employer. You cannot be self-employed. So this program was introduced by Obama in 2017. It was then basically shut down by the Trump administration. But now, under Biden, this program has been revived. It's quite an interesting program. It's quite flexible, which is very, very important for entrepreneurs that are starting a new business, but who want to be able to show through various different documentation that their company will be successful or already is successful. So what are the criteria for this type of parole? Again, this is not a visa exactly. It is not a non-immigrant or immigrant visa, but this is a type of parole, which means that you are legally admitted to the United States and you are able to work. You have work authorization. So it functions basically exactly like a visa or a visa status, but it is a discretionary grant of parole, permission to enter, to work, and direct and develop a new business. So what are the requirements for this new type of parole? Again, it's not exactly a visa, but it's basically exactly the same thing as a visa. I'll explain the differences later. First of all, the entrepreneur must have a significant ownership stake in the startup, so they must own at least part of the startup, at least 10%, and have an active and central role in developing the business, which makes perfect sense. That's what an entrepreneur visa or an entrepreneur program should be. The startup must have been formed in the United States within the past 5 years, so it does have to be a new business, all right, within the last 5 years preceding the application date. Then the business must show that it has raised significant capital or is otherwise able to demonstrate that it will be successful or has already been successful. It has to, the applicant has to show that they've raised a significant capital investment of at least $250,000 from qualified investors with established track records, or the business has attracted significant awards or grants of at least $100,000 from federal or state or local government agencies. Or if the applicant can't show significant capital investment or awards or grants, they can show other reliable and compelling evidence that their business will be successful and will be able to create jobs in the United States and revenue. That could be, for example, admission to a competitive startup accelerator, or perhaps extensive media coverage and interest, or other compelling evidence that the business will be successful. So that's a very flexible standard. All right. So you can either show at least $250,000 in qualified capital investment, or significant awards, at least $100,000 in government awards or grants, or other evidence, which may be a very detailed business plan, perhaps the important clients have expressed interest in this business, or other reliable, compelling evidence. So those are quite flexible requirements. If the applicant is eligible, up to 3 entrepreneurs per startup are allowed to apply, and the initial grant of parole is 2.5 years. And if the entrepreneur is reasonably successful, that can be extended for another 2.5 years. So that's up to 5 years of parole with work authorization in the United States. And the entrepreneur can also bring his family, and his spouse is eligible for work authorization. So this is a very flexible program. We'll see how stringent the requirements are applied. Again, this is a discretionary grant of parole. So this is not a visa application that can be appealed if it's denied, etc. It's completely discretionary. And we'll see how stringent the Biden administration is in actually applying these criteria. But as I'm sure you know, the Biden administration is much more pro-immigrant and pro-foreign investment and pro-job growth and creation via foreign investment than the Trump administration was. Now, let's talk about some specific questions that we've received regarding this program. Again, somebody asked, how many times can the parolee extend this parole? As I said already, it is extendable once. There's an initial application of 2.5 years. The applicant can come in and direct and grow their business here, and they're able to apply for another extension of another 2.5 years for a total of 5 years. Now, in order to extend, they must show that their business has been successful, and the criteria are that they have to show that they have attracted $500,000 in investment during that period, or that they have or they've created a certain amount of jobs during that period. So the business must be successful in order to extend it for another 2.5 years. Now, another common question: can I convert this to a green card, or can I change to another status? Now, that is a disadvantage. This is a grant of parole, which is not a visa status technically. So this is not like being an H-1B status, for example, and it does not qualify the entrepreneur for a green card. Now, that doesn't mean that the entrepreneur, once they are here, they cannot qualify for another non-immigrant or immigrant status, through a separate visa program, such as an H-1B. But an H-1B does require that you find an employer, a U.S. employer, to sponsor the employee, which cannot be an owner of the company. All right, so I think this is, and also the startup business cannot sponsor an owner for a green card normally either. All right, you cannot be self-employed and be sponsored for a green card by your own company normally. So this is not a long-term solution. You would have to still qualify for a non-immigrant visa, a longer-term non-immigrant visa, or a green card through another path. But this is a very good temporary solution and short-term solution, in particular for certain nationalities such as Chinese nationals or Indian nationals that do not have another short-term solution for coming to the U.S. to direct and develop their own company. So I think those are let's see if we have any other questions. What would my immigration status be under this program? Again, this is a grant of parole. This is not a typical non-immigrant or immigrant status. such as an H-1B status, or and it's not a grant of an immigrant visa category such as EB2 or EB3. It does not allow extension of a non-immigrant or non-immigrant status, and it does not lead directly to a green card. This is a discretionary temporary grant of permission to enter, basically, and work for the startup company. All right, another very good question is, what is the difference between the Entrepreneur Parole Program and EB5 or E2? Now, the U.S. does have an investor visa program, which is called the E2 visa. It's a very good visa. It allows an investor to come to the United States to develop and direct a business. If they can show that they've invested a significant amount of money in the U.S. business. But this is only available to certain nationalities, and the company has to be owned and controlled by nationals of that country. So that's quite limiting. For example, this visa is not available for Chinese nationals. It's not available for Indian nationals and certain other nationals. All right, it is available for most all European countries, for Canadian nationals. But even for those countries, there are limits. For example, a Canadian national can come in with an E2 if they're Canadian, of course, and if the company is Canadian owned. So if they were investing in a German company, for example, it would not work. All right, they could not come in and invest in a company that is owned and controlled by German nationals or by any other nationality besides Canadians and get an E2 visa. All right, so that is the limitation of the E2. Now, EB5 is an investor visa, but there is a very high investment threshold now. It's been raised to at least 900,000 or possibly more, and there are very long backlogs. This does lead to a green card, a permanent residence for the investor and their family, but there is a very long backlog for certain nationalities, Chinese nationals in particular. There's at least a 10-year wait, at least, for Chinese nationals. So this is not a short-term solution at all, and there is quite a high initial investment threshold, like I said, at least 900,000. So EB5 is absolutely not a short-term solution for Chinese nationals in particular that have long waits, and it does have a high investment threshold of at least 900,000. Can an investor, entrepreneur, employer sponsor H-1B employees? All right, well, this is a good question. Now, the startup can sponsor H-1B employees that aren't the owner, the entrepreneur. That's, of course, no problem. All right, but unfortunately, the entrepreneur, him or herself, cannot self-sponsor for an H-1B, as I said before. Unfortunately, an H-1B is not permitted for self-employment. The entrepreneur cannot have a controlling interest in the startup business. Now, can this business be reorganized so that it could sponsor the founder for an H-1B? Yes, but the founder would probably have to relinquish ownership of the business, or at least controlling ownership. And there would have to be a board probably that would be able to hire or fire the entrepreneur. There would have to be a relationship of employer-employee. The entrepreneur would have to be an employee who would be subject to dismissal by the company. So it's possible to reorganize the business so that sponsorship for an H-1B is possible, but the entrepreneur would probably have to relinquish control of the business. Now, when can this start? And how does this work? Well, this program technically has been functioning since 2017. Technically, it's been on the books, but Trump issued a rule saying that this was going to be rescinded. Basically, no applications were approved. I believe there was one only that we have a record of approval. So it basically has been non-functional. But in theory, this program is now immediately available as a possibility. Our following question is spouses and children. As I mentioned, the entrepreneur can bring in his or her spouses and children. They would apply at the same time. And the spouse can also apply for work authorization as well. The children cannot. But the entrepreneur can bring his or her family. Okay, what happens if the application is denied? Well, as I mentioned earlier, this is not a normal visa application. This is a discretionary grant of parole. So there really are no options if the application is denied. There is no appeal. There is no appeal process. This is entirely discretionary. The entrepreneur could apply again. There doesn't seem to be any limitation on reapplying. If the entrepreneur can address the issues with the application, perhaps there wasn't enough investment, capital, perhaps the business plan wasn't good enough, etc. But there is no option to appeal the denial. And like I said, we're going to have to see how flexible the Biden administration is in granting these applications. But as I said, it appears the application criteria are quite flexible. Either you show $250,000 in qualifying a capital investment, or you show grants, significant grants, or any other evidence showing the compelling evidence that the business will be successful. So I'm quite hopeful that this will be very workable, that the Biden administration will be applying these criteria in a reasonable way, and this will become a viable option for entrepreneurs to come to the United States and develop and direct their business for up to 5 years in a relatively efficient and rapid way, hopefully. How does this work? Well, the application is submitted to the Immigration Service. There's an application form, and once that is approved, then the applicant goes to the consulate and picks up the entry document. So the process, in theory, could be quite quick, depending on how quickly the processing times are. As we've seen with the Immigration Service during the Trump administration and now during the Biden administration, unfortunately, processing times still have been quite long for many types of visa applications. We'll see how quickly these are adjudicated. But in theory, this could be a relatively quick and efficient way to obtain entry to the United States to develop and direct a startup business. So here at GLG Group, we're very hopeful about this program, in particular for Indian and Chinese nationals that are caught in significant backlogs, who may not be able to use the EB5 program because of the huge backlogs for Chinese nationals in particular, and because of the limitations of the E2 investor visa program, which does not apply to many nationalities. So we'll keep an eye on this program and see how this is actually implemented, and we hope to have an update for our clients and for the entrepreneurial community about the usability of this program and the effectiveness of this program, and we'll be sure to provide updates on a regular basis.